Welcome back. Close your eyes. Let yourself settle. If you're just joining us, we're in the middle of a journey. We're exploring 11 laws, 11 invisible principles that shape human civilization, that govern your life in ways you rarely notice. In our last exploration, we discovered 5 foundational principles. Hammurabi's proportional justice that ended cycles of unlimited vengeance. Rome's written laws that made justice visible for the first time. Magna Carta that placed even kings under the rule of law. Habeas corpus that prevents people from simply disappearing. And the Napoleonic Code's presumption of innocence that changed how we think about accusation and proof. Tonight, we continue. 6 more laws await us. 6 more invisible structures that built the modern world. If you haven't subscribed yet, consider doing so now. These explorations of invisible systems, these quiet journeys through the architecture of civilization, they continue, and you won't want to miss what we discover together. Now, breathe deeply. Let your mind drift backward through time once more. We begin with a question that would have seemed absurd for most of human history. Can you own an idea? Can you possess something intangible? Can creativity itself become property? Let's find out. Law 6. Intellectual property, the ownership of ideas. Let us shift now from criminal justice to a different kind of law, a different kind of protection. One that shapes creativity and innovation and how ideas themselves move through society. How knowledge spreads. How art is created and shared. How inventors profit from their cleverness. We must visit 2 places separated by an ocean but united in their recognition of something unprecedented in human civilization. England in 1710. Parliament passes the Statute of Anne, the world's first copyright law, the first time any government created property rights in the intangible realm of creative works. And America in 1790, the new Constitution, still fresh and untested, includes a clause granting Congress the power to create patent and copyright systems, to establish legal frameworks to promote the progress of science and useful arts. By giving creators temporary monopolies over their creations, these laws do something that would have seemed strange, perhaps even impossible, right, to most humans throughout history. They create property rights in intangible things, in ideas, in stories, in inventions, in melodies, in designs, in the products of human creativity and ingenuity that exist not as physical objects, but as patterns, as information, as expressions of thought. Before intellectual property law, before this legal innovation, if you invented something clever, something useful, something that would make life easier or more productive, anyone who saw it could copy it, could reproduce it, could make their own version and sell it without paying you a penny, without acknowledging your contribution, without compensating you for the years of experimentation and failure that led to your success. If you wrote a book, poured your heart and mind into creating a story or explaining ideas, any printer could reproduce it, could make copies, could sell them, and keep all the profits while you received nothing. Creation was generous, was shared freely whether the creator wanted to share or not, but unrewarded except by the immediate satisfaction of having created something. Copying was easy, often easier than creating, and profitable, much more profitable than the hard work of original creation. Why spend years developing a new technique when you could simply watch what others did and reproduce their innovations? Why spend months writing when you could spend days typesetting someone else's work? Intellectual property law changed this equation fundamentally. It said, with the force of law behind it, if you create something original, something new, something that springs from your mind and your effort, you own it. For a limited time at least. You can control who copies it, who reproduces it, who profits from it. You can license it, can sell it, can keep it to yourself. And then, after that time expires, after you have had the opportunity to profit from your creation, it enters the public domain, becomes part of the common heritage of humanity, available for everyone to use freely without restriction. The psychological impact of this change on human creativity was enormous, transformative. It made professional authorship possible, made it feasible to earn a living through writing rather than relying on noble patronage or inherited wealth. It incentivized invention, made it worthwhile to spend years developing new technologies because you could profit from them before others copied them. It created entire industries built around protected intellectual property, publishing houses, recording companies, film studios, software companies, pharmaceutical corporations, all built on the foundation of temporary monopolies granted by intellectual property law. But it also created tensions, conflicts, dilemmas that remain contested today. How do you balance rewarding creators with allowing knowledge to spread? How long should protection last? How many years before ideas return to the commons? What counts as copying versus being inspired by? Versus building on the work of others? These questions have no easy answers, no perfect solutions, only endless negotiations between competing values and interests. Let us visit a story that illustrates both the power and the problems of intellectual property. A story from the 19th century America when the patent system was still relatively young and the balance between protection and access was still being worked out through countless individual cases. In 1853, in the bustling workshops of Philadelphia, a city known for its craftsmen and inventors and enterprising mechanics, a clockmaker named Isaiah Smith invented an improvement to pocket watch mechanisms. His design made watches more accurate by compensating for temperature variations that affected the balance spring, made them easier to repair by simplifying the escapement mechanism. It was a clever innovation, the result of years of experimentation and careful observation of how watches failed and lost time. Isaiah applied for a patent, submitted his drawings and descriptions to the patent office, and was granted exclusive rights to manufacture and sell watches using his improvement for 14 years, the standard term at that time. This patent protection meant he could invest in his business without immediate competition undercutting his prices, could build a factory, could hire craftsmen, could develop a reputation for quality, knowing that for 14 years the law would protect his innovation from simple copying. He built a small factory on the outskirts of Philadelphia, hired skilled watchmakers, trained apprentices in his methods. His watches gained a reputation for accuracy and reliability. Merchants and professionals bought them. Railroad companies, which needed accurate timekeeping for safe operations, purchased them in quantity. Isaiah prospered, not becoming wealthy in the way of industrial magnates, but earning a comfortable living from his cleverness, from his innovation, from his years of patient work. But in New York, Another watchmaker named Thomas Brown saw Isaiah's design, studied the watches, understood the principles, and was inspired. Thomas created his own improvement, similar in function but different in mechanism, using a different approach to temperature compensation, a different design for the escapement. Was this copying or independent innovation? Was this theft of intellectual property or the natural progression of technology? Was this infringement or the kind of incremental improvement that drives progress? They ended up in court. Patent lawyers arguing about where inspiration ends and infringement begins, about whether similar function implies copying even when the mechanism differs, about how much protection the law should give to basic ideas versus specific implementations. The judge ruled in Thomas's favor. His design was sufficiently different, was not mere copying but genuine innovation that built on publicly available knowledge. This was not theft, but the healthy competition and incremental improvement that the patent system was designed to encourage. Both patents could coexist. Both inventors could manufacture their improvements. The market would decide which design was superior. This story, repeated thousands of times across the 19th century as America transformed into an industrial power, played out in workshops and courtrooms and patent offices, illustrates a delicate balance that intellectual property law tries to strike. The patent system encouraged Isaiah to invest time and resources in developing his improvement, gave him protection that made innovation worthwhile. But it did not give him a monopoly on the basic concept of temperature compensation, did not prevent others from approaching the same problem differently, did not stop the incremental improvements and competitive innovations that drive technological progress. The psychological effect was powerful, widespread, transformative of how Americans thought about innovation and entrepreneurship. People believed they could profit from cleverness, from mechanical ingenuity, from finding better ways to do things. This incentivized tinkering, experimentation, entrepreneurship. The patent system created a feedback loop where innovation led to reward, which led to more innovation, where clever mechanics could become prosperous businessmen, where a good idea could transform your economic prospects. But there was a darker side, complications that emerged as the system matured. Patents could be used to block competitors even when the patent holder was not manufacturing anything themselves. Patent trolls emerged. Individuals or companies who bought patents not to make products, but just to sue others for infringement, to extract licensing fees, to use the legal system as a weapon rather than as a protection for genuine innovation. The system meant to encourage innovation could be weaponized to stifle it, could become a barrier rather than an enabler, could enrich lawyers and speculators rather than inventors and creators. In the modern world, in the world you inhabit right now as you drift towards sleep, intellectual property shapes your life in countless ways, in ways you barely notice until you stop to think about them. The software you use on your phone and computer is protected by copyright, exists as intellectual property that you license rather than own. The medicines you take when you are sick were developed under patent protection, with pharmaceutical companies investing billions in research because they know they will have exclusive rights to sell successful drugs for a period of years before generic versions become available. The books you read, the movies you watch, the music you hear, all exist within frameworks of intellectual property law. All involve complex negotiations between creators and audiences, between protection and access, between private profit and public good. This creates a complex psychology around creativity and ownership, around what it means to create something and what rights that creation gives you. You likely believe that creators should profit from their work, that authors should be paid for their books, that musicians should earn money from their songs, that inventors should benefit from their innovations. But you also likely feel frustrated by overly restrictive copyright, by patent abuse, by cases where intellectual property law seems to serve lawyers and corporations more than actual creators, by situations where important knowledge is locked behind paywalls or protected by patents that prevent access to life-saving medicines. The tension is inherent in the system, built into the very structure of intellectual property law. It tries to balance private incentive with public good, tries to give creators enough control to make creation worthwhile, but not so much control that knowledge and culture become locked away from the public forever. Tries to encourage innovation while ensuring that the foundations on which all innovation builds remain accessible to future creators. In your own life, if you've ever created something, written something, designed something, made something original that came from your mind and your effort, you have likely thought about intellectual property. Who owns this? Can I protect it? Would registering a copyright or applying for a patent make sense? Or would it be better to simply share it, to let it spread freely, to contribute to the commons rather than claiming ownership? These questions would have been meaningless for most of human history, would have seemed strange to people who assumed that ideas were common property, that once something was known, it was free for anyone to use, that creativity was its own reward, and expecting legal protection for intangible creations was absurd. Intellectual property law created ownership of the intangible, created property rights in ideas and expressions and innovations. This has driven enormous creativity and innovation, has created industries, has made professional creativity possible for millions of people. But it has also created conflicts that seem to intensify as technology makes copying ever easier, as digital reproduction reduces the cost of copying nearly to zero, as the internet makes distribution instantaneous and global. The balance remains elusive, contested, subject to constant negotiation and revision. Copyright terms keep getting longer, patents keep getting broader, but resistance grows too. Open source movements, Creative Commons licensing, calls for patent reform, demands for access to knowledge and culture, the struggle between protection and access, between private rights and public goods, continues with no final resolution in sight. As you drift towards sleep now, as your thoughts become less linear and more dreamlike, consider this. Every story you enjoy, every invention you use, every song you love, every piece of software that makes your life easier exists within frameworks of intellectual property law. These laws shape what gets created, how it spreads, who profits from it. The world of ideas is not a commons anymore, not a shared space where everything flows freely. It is a landscape of temporary monopolies, granted to encourage creation, expiring to serve the public good, trying to balance individual reward with collective benefit. trying to make creativity profitable while keeping knowledge eventually free. Sleep peacefully now. The ideas that fill your world, that educate you, that entertain you, that make your life richer and easier, were shaped by legal structures you barely notice, by frameworks established centuries ago to answer the question of whether ideas can be owned, and if so, for how long, and under what conditions. The answer is complex, imperfect, constantly evolving, but it has made possible much of the creativity and innovation that defines modern life. Rest well. Dream. And perhaps in your dreams, ideas will flow freely, without ownership or restriction, returning for a few hours to the commons from which intellectual property law extracted them, returning to the realm where creativity is its own reward and sharing is natural, before waking again into a world where ideas are property, protected by law, owned for a time, before eventually returning to us all. Good night. Law 7. Corporate personhood, when companies became people. Now we venture into stranger legal territory, into a concept that seems almost philosophical, almost metaphysical, but has enormous practical implications for how economies function, how power is organized, how responsibility is assigned or avoided in the modern world. We must explore the concept of corporate personhood, the legal fiction, the useful pretense that a corporation is, in some meaningful ways, a person. This idea has roots stretching back centuries, back to medieval guilds that had legal identities separate from their members, back to chartered trading companies like the Dutch East India Company or the British East India Company that were granted royal charters giving them rights and powers beyond what any individual merchant could possess. But the concept crystallized in the 19th century, particularly in the United States with cases like Dartmouth College versus Woodward in 1819, and later Santa Clara County versus Southern Pacific Railroad in 1886. Cases that establish corporations as legal persons with rights and protections under the Constitution. The core concept is simple but profound. A corporation can own property, can sign contracts, can sue and be sued, can enter into agreements and be held to them, all as if it were a person, an individual human being with agency and will and legal standing. But unlike actual persons, unlike you or me, a corporation does not die, does not age, does not have a limited lifespan measured in decades. It continues existing, continues operating, continues accumulating wealth and power, as long as it maintains its legal status, as long as it files the proper paperwork and pays its fees and follows the minimal requirements for corporate existence. And crucially, most importantly for understanding how this changed economics and psychology, the people who own shares in the corporation are not personally liable for its debts or crimes beyond their investment. If the corporation fails, if it goes bankrupt, if it owes money it cannot pay, the shareholders lose their investment but not their houses, not their savings, not their personal assets beyond what they chose to invest in the corporate venture. This feature, this principle called limited liability, transformed economics in ways difficult to overstate. It meant you could invest in a risky venture without risking everything you owned, without putting your family's security on the line, without gambling your entire future on one business decision. If the company failed, you lost your investment, painful but survivable, but not your home, not your children's future, not everything you had worked to build. This made capital formation possible on a scale previously unimaginable. It allowed ordinary people to invest in large enterprises, to pool resources with thousands of other investors, to fund railways and factories and mines and shipping companies that no individual could finance alone. It created the possibility of massive industrial enterprises, of corporations with resources exceeding those of many governments, of economic entities that could reshape landscapes and economies. The psychological impact on economic behavior was revolutionary, profound. Limited liability encouraged risk-taking, encouraged investment in uncertain ventures, encouraged entrepreneurship and innovation because the downside was capped, was limited, was survivable. People would invest in new technologies, in experimental processes, in speculative ventures, because while they might lose their investment, they would not lose everything. The worst case was no longer total ruin, was no longer the destruction of everything you had built over a lifetime. This unleashed enormous economic dynamism, drove industrialization, funded the railways and telegraphs and factories that transformed agrarian societies into industrial powerhouses, created wealth on scales previously unimaginable, but it also created moral hazard, created situations where corporations could take enormous risks with other people's money, with workers' lives, with public safety, with the environment, and the individuals making decisions were partially insulated from consequences. Let us visit a story that illustrates both the power and the peril of corporate personhood. A story that captures how this legal innovation could drive economic development while also enabling abuses that left victims with little recourse. In 1892, in the mountains of Colorado, where silver and gold drew thousands of prospectors and mining companies, a corporation called the Silver Queen Mining Company operated several mines in the high country above tree line. The company was legally a person, distinct from its owners. The owners were wealthy investors in New York and Boston, men who had never visited Colorado, or had never seen the mines, had never descended into the dark tunnels where their employees worked. They owned shares, received dividends when the mines were profitable, but remained distant from the actual operations, insulated by distance and by the legal structure of the corporation from the daily realities of mining. The mines were dangerous, inherently dangerous in ways that mining has always been dangerous. Deep tunnels, unstable rock, explosive gases, flooding, collapse, all constant threats. Safety equipment was expensive. Proper timber supports cost money. Ventilation systems cost money, regular inspections cost money, and the company's managers, under pressure to maximize profits, under pressure to keep costs down, under pressure to send larger dividends to those distant shareholders, skimped on safety measures. A collapse killed 17 miners. A tunnel gave way, tons of rock fell. Men were crushed or trapped or suffocated in the darkness. 17 families lost fathers, brothers, sons. 17 funerals in the small mining towns. 17 graves in the rocky soil of Colorado. The families sued, sought compensation, sought justice. But they faced a legal puzzle that made justice elusive. Who was responsible? The company's owners had never visited the mines, had never made decisions about safety equipment, had never inspected the tunnels. They simply owned shares. simply invested capital, simply expected returns? The managers claimed they were just following company policy, just trying to keep costs down, just doing what they were hired to do, just serving the corporation's interests. The company itself, as a legal person, could be sued, but its assets were limited, and bankruptcy would leave the families with little compensation. Under older legal frameworks, before corporate personhood and limited liability, where business owners were personally liable for everything their businesses did, those New York and Boston investors would have risked their personal fortunes, their mansions, their bank accounts, their comfortable lives. All would have been at stake. This risk would have incentivized them to ensure safety even in mines they never saw, would have made them care about working conditions even for employees they never met, because their own wealth, their own security was on the line. But corporate personhood and limited liability insulated them, protected them from personal consequences. They lost their investment when the company folded under the weight of lawsuits and decline in silver prices, but their mansions remained intact, their bank accounts untouched, their comfortable lives unchanged. The families received minimal compensation. The investors moved their capital to other ventures. The system had made it easy to invest in mining, had encouraged capital to flow into extractive industries, had driven economic development in Colorado, but it had also made it easy to take risks with other people's lives. This tension remains today, perhaps more acutely than ever. Corporate personhood enables the large-scale enterprises that create jobs, that drive innovation, that generate wealth, that make modern life possible. Corporations build the infrastructure you rely on, manufacture the products you use, provide the services you depend on, employ millions of people, create economic opportunities that would not exist without the ability to pool capital and limit liability. But corporate personhood also creates entities that can wield enormous power while diffusing responsibility so thoroughly that holding anyone accountable becomes nearly impossible. When a corporation causes harm, pollutes a river, sells defective products, creates dangerous working conditions, who is responsible? The CEO says he was following shareholder interest, maximizing value as the law requires him to do. Shareholders say they just owned stock, just invested in a diversified portfolio, just tried to save for retirement. Employees say they were following orders, executing policies made by others, doing their jobs. The corporation itself is merely a legal structure, a fiction, incapable of intention or guilt in any human sense. Yet our minds struggle to think about corporations in purely abstract terms. We personify them. We say Amazon did this, or Exxon knew that, or Facebook decided. We assign them motivations, characters, even values and principles. We treat them as moral agents, as entities capable of good or evil, as actors in the drama of modern life. This mental shortcut helps us navigate a complex economy, helps us make sense of interactions with entities that are neither individuals nor governments, but it also obscures the reality that corporations are tools, are legal constructions created by law, shaped by incentives, controlled by people who are often partially hidden behind the corporate veil, people who may have interests that diverge from the corporation's stated purposes, people who may profit from corporate actions while avoiding personal responsibility for corporate harms. in your own life, in the world you inhabit as you drift towards sleep now. You interact with corporate persons constantly. Every time you shop at a major retailer, bank with a financial institution, work for a company, invest in stocks or mutual funds, you are engaging with these legally constructed entities. They shape employment opportunities, structure markets, dominate public discourse, fund political campaigns. They are some of the most powerful forces in modern life. Yet they exist only because law says they do. The psychology of corporate personhood creates a strange moral landscape, a confusing ethical terrain. When a corporation harms you, whom do you blame? Whom do you hold responsible? Whom do you seek restitution from? When a corporation does good, creates jobs, develops life-saving medicines, builds useful infrastructure, whom do you thank? Whom do you credit? Whom do you reward? The diffusion of agency makes both praise and blame feel hollow, makes both accountability and gratitude difficult to direct. Yet the system persists because it solves real problems, because limited liability really does encourage investment and risk-taking, because corporate personhood really does enable economic coordination on scales that would be impossible without it, because for all its problems and perversities, the corporate form has proven useful, perhaps necessary, for organizing complex economic activity in industrial and post-industrial societies. As you settle into sleep now, as your conscious mind releases its grip and allows dreams to emerge, ponder this oddity, this strange feature of modern life. Some of the most powerful persons in your world are not alive, are not conscious, are not capable of genuine intention or moral reasoning. They are legal fictions, maintained by paperwork, animated by capital, wielding influence beyond any individual human, buying and selling, employing and firing, polluting and cleaning up, innovating and resisting change. Corporate personhood is a magic spell cast by law, transforming ink on paper into entities that can buy, sell, employ, pollute, innovate, sue, and be sued. The spell is so powerful we forget it is a spell, forget that these entities exist only because we collectively agree to pretend they are persons. Forget that we could choose different legal structures, different ways of organizing economic activity, different allocations of risk and responsibility. Rest now, peacefully. The economy you participate in is structured by this legal fiction. You work for persons who are not people. You buy from persons who cannot die. You own shares in persons who have no body, no mind, no soul. This strange inversion of reality and abstraction, this elevation of legal fictions to the status of persons while actual persons become merely shareholders or employees or consumers. This is a foundation of modern economic life, invisible until examined, undeniable once seen, shaping everything while calling attention to nothing. Sleep, dream, perhaps in your dreams, corporations will dissolve back into what they are, collections of people, groups of individuals, coordinated activities, stripped of their legal personhood, revealed as the useful fictions they are, before you wake again into a world where companies are people, where legal entities have rights, where the most powerful actors in our society are neither human nor divine, but something in between, something we created, something that now shapes us in return. Law 8, Miranda writes, the right to remain silent. We return to criminal justice now, but in the modern era, in living memory for many who are still alive today. The United States, 1966. The Supreme Court decides Miranda versus Arizona, and in doing so creates something that will be immortalized in countless films and television shows. Something that will become so deeply embedded in American culture that people who have never been arrested can recite the words. Something that represents a profound attempt to rebalance the inherent power imbalance between police and suspects. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. These words, or variations of them, must be spoken by police to anyone in custody before interrogation begins. The principle is simple but revolutionary. People must know their rights before they can be expected to protect them. People must be explicitly informed that they can refuse to speak, that they can demand a lawyer, that they are not helpless even in the face of a police authority. This seems simple, seems obvious, seems like basic fairness, but it represents a profound shift in the psychology of police interrogation and criminal procedure. A recognition that the interrogation room is inherently coercive, that custodial questioning creates psychological pressures so intense that people need explicit reminders of their legal protections. Before this decision required police to inform suspects of their rights. Police could and did extract confessions through methods that stopped just short of overt torture. Marathon questioning sessions lasting 10, 12, 16 hours. Psychological manipulation, playing on fears and insecurities. Deception about evidence, telling suspects that witnesses had identified them, that their fingerprints were found, that their friends had confessed and blamed them. All lies but effective lies. Isolating suspects for days. Denying them sleep, denying them food, denying them contact with family or lawyers, wearing down their resistance until they would say anything just to make it stop. People confessed to crimes they did not commit. This was not speculation, not theory, but documented fact. The pressure of interrogation, especially for those who were poor, uneducated, mentally vulnerable, could break anyone, could extract false confessions that seemed voluntary but were anything but. And once a confession was obtained, even if coerced through psychological manipulation rather than physical torture, it was extremely difficult to overcome at trial. Juries believed confessions. Why would anyone confess to a crime they did not commit? It seemed irrational. Seemed like proof of guilt, seemed like the end of the case. But psychological research showed that people absolutely would and did confess falsely under sufficient pressure. Exhaustion breaks down judgment. Fear overwhelms rationality. Desire to end questioning, to escape the interrogation room, to stop the psychological pressure, can lead even innocent people to confess. Trust in promises that cooperation would lead to leniency, that honesty would be rewarded, that confessing to a lesser charge would avoid conviction for a greater one. All these psychological factors could lead people to confess to things they never did. Miranda rights attempted to rebalance the interrogation room to create a psychological buffer in the inherently unequal encounter between police and suspect. By requiring that suspects be informed of their right to silence and to counsel, the law acknowledged that custodial interrogation is inherently coercive, that the psychological pressure of being held by police, questioned in an isolated room, separated from family and support, is so intense that people need explicit reminders of their legal protections. Let us visit a story that illustrates why this matters. Why these rights are not mere technicalities but crucial protections for vulnerable people facing the enormous power of the state. In 1990, in Baltimore, in a neighborhood where police presence was constant but trust in police was low, a teenager named Marcus was arrested on suspicion of robbery. He was 16 years old, scared, had never been arrested before, knew nothing about the legal system beyond what he had seen on television. He was taken to an interrogation room, a small windowless space, just a table and chairs, a mirror that he suspected was one-way glass, cameras recording everything. The detectives were not overtly abusive. They did not hit him, did not threaten him with violence, did not use the rubber hoses and phone books of earlier eras, but they were skilled, experienced, trained in psychological techniques of interrogation. They knew how to build pressure, how to create stress, how to manipulate a frightened teenager into saying what they wanted to hear. They questioned him for 5 hours. 5 hours in that small room, no windows, no clock, no sense of time passing, just the endless questions and accusations. They told Marcus his fingerprints were found at the scene. They were not. No fingerprints had been recovered. But Marcus did not know this was a lie. They said his friends had already confessed and blamed him. They had not. Marcus had no friends involved in any robbery, but he did not know this was a manipulation. They promised that if he just told the truth, if he just came clean, if he just admitted what really happened, they could work something out, could talk to the prosecutor, could help him get a lighter sentence. But if he kept denying, if he kept lying, if he kept protecting others, he would face the maximum sentence, would be tried as an adult, would spend years in prison. Marcus had been read his Miranda rights when arrested. The officers had recited the word, had asked if he understood them, had gotten his acknowledgement that he did. But he did not truly understand. Not really. Not in any meaningful way. He thought asking for a lawyer would make him look guilty. Why would an innocent person need a lawyer? He thought remaining silent would anger the detectives, would make them think he was being difficult, would make things worse. He was not educated about how the system worked, had no experience with criminal justice, believed the lies about evidence because he had no reason to think police would lie. After 5 hours, exhausted, frightened, desperate to escape that room, he confessed to a robbery he did not commit. His public defender later had the confession thrown out. The interrogation, while technically following Miranda by reading the rights at the beginning, had been psychologically coercive, had exploited Marcus's youth and ignorance, had used deception and pressure to extract a false confession. But this only happened because Marcus had a competent defender who understood these issues, who knew to challenge the confession, who recognized the psychological coercion beneath the technically legal surface. Many people do not get such representation, do not have lawyers who know to challenge confessions, do not have advocates who understand the psychology of false confessions. The Miranda decision tried to create a psychological buffer, tried to give suspects a mental framework for understanding they can protect themselves. by requiring that rights be stated clearly at the outset, before questioning begins. The law attempts to plant in the suspect's mind the knowledge that silence is an option, that demanding a lawyer is not an admission of guilt but a protected right, that they are not helpless even in the face of police authority. The psychological impact on American culture has been enormous. Miranda warnings are so ubiquitous in media, in cop shows and movies and crime dramas, that most Americans can recite them by heart, even if they have never been arrested. This cultural saturation has created broad awareness of these rights, which is precisely what Miranda intended. The more people know these rights exist, the more familiar they are with the language, the more likely they are to exercise them when needed. But knowledge and exercise are different things. Psychologically, exercising Miranda rights is difficult. Remaining silent feels like an admission of guilt, feels like you have something to hide, feels wrong when you know you are innocent and want to explain. Asking for a lawyer feels confrontational, feels like you are not cooperating, feels like it will make police suspicious and angry. The social pressure to cooperate, to explain yourself, to prove innocence through words is intense even when you know intellectually that you have the right to stay quiet. Police interrogation continues to be highly effective despite Miranda. Skilled interrogators can work around it, can create atmospheres where suspects waive their rights and talk, can build rapport, can offer sympathy, can suggest that exercising rights looks guilty, can make cooperation seem wise and silence seem foolish. The psychology of interrogation, the techniques of building pressure while maintaining a veneer of friendliness, remain powerful tools even in the post-Miranda world. Yet Miranda has made a difference. Confessions are scrutinized more carefully than before. Coerced confessions are more likely to be thrown out, more likely to be challenged, more likely to be recognized as potentially unreliable. The legal system recognizes, at least in principle, that interrogation is psychologically fraught, that people need protection even from themselves when facing the power of the state, that confessions extracted under psychological pressure may be false even when they appear voluntary. In your own life, as you drift towards sleep now, you likely hope you will never need Miranda rights. Hope you will never sit in an interrogation room, never face police questioning while in custody, never have to decide whether to speak or stay silent, whether to demand a lawyer or try to explain yourself. But knowing these rights exist shapes your understanding of criminal justice, shapes how you think about police power and individual protection. When you watch a crime drama and see someone invoke their right to remain silent, you understand this is legally protected. Understand they are not required to speak. Understand that silence cannot be used as evidence of guilt. When you hear about false confessions, about innocent people who confessed under pressure, you understand why suspects need lawyers, why the right to counsel exists, why people need protection even when they believe they can help themselves by talking. The psychological framework Miranda created has become part of common knowledge, part of how Americans think about criminal justice, part of the mental landscape of rights and protections that most people carry even if they never personally need to invoke them. As you drift deeper into sleep, deeper into that space where conscious thought gives way to dreams, let this thought settle into your mind. you have the right to remain silent. This is not just a legal principle, but a psychological protection. Recognizing that speech can be compelled through pressure short of violence, that people need explicit permission to not answer questions, that the state's power to interrogate must be balanced by the individual's right to silence. Sleep now. Your silence is protected. Your right to counsel is guaranteed. These shields against the immense power of the state exist because 60 years ago, the Supreme Court recognized that people facing police interrogation need explicit reminders of their rights, need legal structure around their fear, need protection even when they do not know to ask for it, rest peacefully. The words, "You have the right to remain silent," are more than a ritual, more than a formality police must recite before questioning. They are a recognition that power must be checked, that vulnerability must be protected, that the intimidating authority of police interrogation must be balanced by clear, explicit, unambiguous reminders that you are not helpless, that you have rights, that you can protect yourself by refusing to speak. Good night. Sleep. Dream. And if you ever find yourself in that interrogation room, may you remember these words. May you find the courage to exercise these rights. May you understand that silence is not guilt, that demanding a lawyer is not obstruction, that protecting yourself is not wrong, even when authority figures suggest that cooperation is the only innocent choice. Rest well. Law 9. Double jeopardy. One trial, one chance. We stay in the realm of criminal justice for our 9th law, exploring a principle that seems simple, but carries profound psychological and practical implications for how justice operates, how finality is achieved, how the state's power to prosecute is limited. The prohibition against double jeopardy. The Fifth Amendment to the United States Constitution states clearly, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." In plainer language, in words everyone can understand, if you are tried for a crime and acquitted, if a jury finds you not guilty, the government cannot try you again for the same offense, not even if new evidence emerges proving your guilt beyond any doubt. Not even if witnesses come forward, not even if the truth becomes absolutely clear after the trial ends. This principle exists in various forms in most legal systems influenced by English common law. Once jeopardy attaches, once a jury is sworn, once a judge begins hearing your case, the state gets one chance to convict you, one opportunity to prove guilt, one shot at securing a conviction. If they fail, if the jury acquits, if the judge dismisses charges, you walk free forever regarding that particular offense, regardless of what evidence might later come to light. The psychological weight of this rule is immense for defendants, almost unbearable when you truly consider what criminal trial means. Imagine facing trial, standing accused, your freedom hanging in the balance, your reputation at stake, your future uncertain, the anxiety, the fear, the sleepless nights, the constant worry. Everything hangs in the balance during that trial. Your freedom, your reputation, your ability to work, your relationships, your entire future. Now imagine that if acquitted, you could be tried again, and again, and again, as many times as the prosecution wished to bring charges, as many times as they could convince a judge to allow another trial. The state has unlimited resources, unlimited time, unlimited opportunities to refine their case, to find new witnesses, to develop new theories, to try different approaches. You would be ground down, bankrupted by legal fees even if you won every trial, exhausted by repeated court appearances, worn away by the psychological strain of endless prosecution, until eventually, perhaps, a jury convicted you simply because they had heard the same accusations so many times that guilt seemed inevitable. Double jeopardy prevents this nightmare, makes it impossible, creates finality in criminal prosecution. It makes trial genuinely high stakes for the prosecution as well as the defense. The state must prepare carefully, must present their best evidence the first time, must prove their case beyond reasonable doubt in one shot, because they will not get another chance. This focuses prosecutorial resources, prevents harassment through repeated prosecution, creates pressure on the state to get it right the first time rather than treating trials as practice runs. But it also means that guilty people can go free, can walk away from crimes they actually committed, can escape punishment entirely if the prosecution bungled the first trial, if key evidence was excluded on technicalities, if the jury was sympathetic for reasons unrelated to guilt or innocence, if luck or chance resulted in acquittal despite actual guilt, the guilty defendant walks, and the state can do nothing about it. Let us visit a story that captures both the justice and the frustration of this principle, a story that illustrates why double jeopardy exists and why it creates such strong emotions. In 1995, in Los Angeles, the world watched as O.J. Simpson, former football star, celebrity, household name, was tried for the murder of his ex-wife Nicole Brown Simpson and her friend Ronald Goldman. The trial was a media circus, lasting months, dominating news coverage, exposing racial tensions in American society, problematic police procedures, the capabilities of expensive defense attorneys, and the ways that fame and wealth can shape criminal justice outcomes. The evidence seemed strong to many observers. Blood at the scene, DNA matches, a history of domestic violence, a motive. But the defense raised questions about police misconduct, about evidence handling, about racial bias in the investigation, about whether Simpson could receive a fair trial given the publicity. The jury deliberated for less than 4 hours and returned a verdict that shocked much of the nation. Not guilty, acquitted, free to go. The criminal trial ended. Due to double jeopardy, Simpson could never be tried again for these murders in criminal court, no matter what evidence might emerge, no matter what witnesses might come forward, no matter how clearly his guilt might later be established. The Fifth Amendment protected him. The prohibition against double jeopardy meant the state had gotten its one chance, had presented its case, and had lost. That loss was final for criminal purposes. The families of the victims were devastated, felt cheated of justice, felt that the system had failed, but they were not without legal recourse. They filed a civil suit, which is not barred by double jeopardy because civil proceedings do not put anyone in jeopardy of life or limb. Civil trials do not result in imprisonment, do not threaten liberty in the same way, and therefore can proceed even after criminal acquittal. The civil trial, with its lower burden of proof, preponderance of evidence rather than beyond reasonable doubt, with its different procedural rules, with its different jury, found Simpson liable for the deaths. He was ordered to pay millions in damages to the families, did not go to prison, but faced financial consequences. This outcome illustrates both the protection and the limitation of double jeopardy. Simpson faced criminal trial once. The state presented its case with all its resources, with experienced prosecutors, with extensive investigation. The jury acquitted. Whether this was because of reasonable doubt genuinely felt, or jury nullification, or sympathy for Simpson, or distrust of police, or simple error, the result was final for criminal purposes. He could not be criminally retried, could not face another criminal jury, could not be imprisoned for these offences no matter what anyone later learned or proved. But civil liability remained possible because it is a different legal category, with different standards, different stakes, different constitutional protections. The families could seek justice through civil courts even after criminal acquittal, could hold Simpson financially accountable even though he could not be imprisoned. The psychological impact of double jeopardy on how society thinks about justice is complex, contradictory, deeply felt on all sides. On one hand, it creates finality, and we value finality in legal proceedings. We need cases to end, need closure, need to be able to move forward rather than endlessly relitigating the same charges. Endless retrials would make justice feel arbitrary, would make outcomes seem dependent not on truth but on how many times prosecution could afford to try, on which jury happened to hear which version of the case. On the other hand, double jeopardy creates situations where known criminals go free because of technical errors in one trial, where guilty people escape punishment because prosecutors made mistakes, where victims and their families must live with the knowledge that the person who harmed them walks free and can never be held criminally accountable no matter what evidence emerges. This frustrates our sense of justice, our desire for truth to prevail regardless of procedure, our feeling that outcomes should be determined by actual guilt rather than by the competence of prosecutors or the particular composition of one jury. But double jeopardy embodies a choice, a deliberate decision about what we fear more from government. Better that some guilty go free than that anyone face the harassment and resource drain of unlimited retrials. Better that criminals occasionally escape than that the state have unlimited power to prosecute until it achieves the outcome it wants. This choice reflects a deep psychology about power and its proper limits. The protection against double jeopardy gives defendants crucial psychological peace. If you are acquitted, you can breathe, truly breathe. For the first time since charges were brought, it is over, finally over. The state cannot come for you again on those charges, cannot drag you back to court, cannot retry you even if they find new evidence. This allows life to resume, provides closure, recognizes that being prosecuted itself is a punishment even if you are ultimately acquitted, that the process is the punishment in many ways, and that at some point it must end. For prosecution, double jeopardy creates intense pressure. You must get it right the first time, must not rush to trial before you are ready, must not bring charges on weak evidence hoping to strengthen the case later, must prepare thoroughly because you will not get a second chance. This incentivizes careful investigation, strategic decision-making about when to bring charges, thorough case preparation before trial begins. In the modern world, in your world, in the legal system that governs you as you drift towards sleep, you are protected by double jeopardy. If you were ever charged, tried, and acquitted of a crime, the state could not retry you for that offense, could not drag you back to court, could not subject you to the anxiety and expense and psychological trauma of another trial for the same alleged crime. This protection might seem abstract until you need it, at which point it becomes a shield of immense value. As you sink into sleep now, as consciousness fades and dreams approach, let this thought comfort you. You get one trial, not endless trials. The state gets one chance to prove guilt, not infinite chances to wear you down. This limitation on government power to prosecute reflects a fundamental choice about what kind of justice system we want, one with finality, even if that sometimes means the guilty go free, rather than one with unlimited retrials that could grind anyone down through sheer repetition and resource exhaustion. Rest peacefully. The protection against double jeopardy stands between you and endless prosecution, ensuring that criminal justice has an endpoint, that acquittal means something permanent and real, that the power to prosecute is genuine and important, but also limited and bounded, that the state cannot simply keep trying until it gets a result it wants. Sleep now. Dream without fear of endless trials, without worry that acquittal is merely temporary, without anxiety that the state will return again and again until your resources are exhausted and your resistance is broken. Double jeopardy prevents this, creates finality, allows you to move forward after acquittal, knowing that this chapter is closed forever. Good night. Rest well. The principle that you cannot be tried twice for the same offense is woven into the constitutional fabric that protects you, invisible but strong, rarely noticed until needed, absolutely crucial when it matters, standing between you and the nightmare of endless prosecution, of justice that never concludes, of acquittal that means nothing because the state can always try again. Sleep. Law 10. Statute of Limitations. When justice expires. Our 10th principle is perhaps the most philosophically troubling, the most difficult to accept emotionally, even when we understand it intellectually. The concept that for most crimes, prosecution must begin within a certain time period, or the right to prosecute expires forever. The statute of limitations. The principle that justice has a deadline. Different crimes have different limitation periods. Minor offences might have statutes of 1 or 2 years. More serious crimes might have 5, 10, or 20 years. Murder and some other heinous crimes often have no statute of limitations at all, can be prosecuted decades or even centuries later if evidence emerges. But for most offences, for the vast majority of crimes, there is a deadline, a point beyond which the state cannot bring charges no matter how clear evidence, no matter how certain the guilt. Wait too long, and the crime becomes legally unprosecutable. Why would we set time limits on justice? Why would we create a system where criminals can escape punishment simply by waiting, by hiding, by letting years pass until they are safe from prosecution? The reasons are both practical and philosophical, both straightforward and deeply troubling. Practically, evidence degrades over time, inevitably, unavoidably. Witnesses die or forget. Memories fade and become unreliable. Physical evidence deteriorates, is lost, is contaminated by time and handling. Documents are destroyed, lost in fires or floods or simple carelessness, are thrown away by people who do not realize their significance. Trying to prosecute a decades-old crime becomes extremely difficult, sometimes impossible. The risk of wrongful conviction increases dramatically when memory has faded and evidence has vanished, when the only testimony available is decades-old recollections that may be sincere but mistaken. Philosophically, statutes of limitations reflect a belief that at some point, society should let go, should move forward, should accept that the past is past. If someone committed a crime long ago and has lived a law-abiding life since, perhaps dragging them to trial serves no purpose. Perhaps they have, in effect, reformed through time, through decades of good behavior, through building a new life. Perhaps the person they are now is not the person who committed that crime decades ago. Perhaps time changes identity enough that prosecuting the current person for the past person's crime becomes unjust. This is psychologically complex, deeply troubling to our moral intuitions. We have strong feelings about justice demanding accountability regardless of time. If someone murdered, if someone raped, if someone committed terrible crimes that destroyed lives and shattered families, the passage of time does not erase the harm, does not heal the wounds, does not remove the moral stain. The victims are still harmed, still suffering, still living with the consequences decades later while the perpetrator lives free. Yet statutes of limitations force us to confront difficult truths about the relationship between time, identity, and justice. Truths that make us uncomfortable, but that the law nevertheless must address. Let us visit a story that illustrates this tension, that captures why statutes of limitations exist and why they create such powerful emotional responses. In 1970, in New York City, in an apartment in a neighborhood that was not yet gentrified, a young woman named Rebecca was assaulted in her home. The crime was violent, traumatic, life-altering in ways that would echo through decades. She reported it to police immediately, underwent the invasive and humiliating process of evidence collection, gave statements, tried to help, but investigations went nowhere. No suspect was identified. No arrests were made. The case grew cold, filed away with thousands of other unsolved crimes. Rebecca tried to move on with her life. What else could she do? She finished college despite the trauma, started a career in publishing, got married to a kind man who knew about what had happened and loved her anyway, had children, built a life around the trauma, managed the psychological scars through therapy and time, found ways to function and even thrive despite what had been done to her. In 1985, 15 years after the crime, a man named Daniel was arrested for an unrelated offense, a different crime in a different borough. During processing, his DNA was collected, a routine procedure that had recently become standard. But this was before widespread DNA databases, before the technology existed to efficiently match samples. The sample sat in storage, waiting for technology to catch up. In 2005, 35 years after Rebecca's assault, advances in DNA technology and computerized databases led police to review old cases, to run old evidence through new systems, to see what cold cases might be solved with modern science. Daniel's DNA matched evidence from Rebecca's assault. After 35 years, Police finally had their perpetrator, finally knew who had committed this crime, finally had conclusive proof. But the statute of limitations for the crime in New York at that time was 5 years. The prosecution could not bring charges, couldn't put Daniel on trial, could not seek justice for Rebecca no matter how conclusive the evidence. Daniel could not be tried, could not be convicted, could not be punished. The evidence of guilt was as certain as DNA evidence can make it. But legally, it was too late. Justice had an expiration date, and it had passed while Rebecca waited for answers. Rebecca was devastated. She had waited 35 years for answers, had carried the trauma through her entire adult life, had built her life around this wound, and now that answers existed, now that she finally knew who had hurt her, the law said they came too late, said that time had erased the possibility of justice, said that Daniel was safe from prosecution because years had passed. This story, repeated in variations across many jurisdictions, with different victims and different crimes, but the same heartbreaking conclusion, led to reforms in many states. Many states eliminated or extended statutes of limitations for serious sexual crimes, especially once DNA evidence became available. The psychological impact of telling victims, "We know who hurt you, but it is too late to prosecute," proved too cruel, too obviously unjust, too hard to defend to people whose lives were shattered by crimes that could now be proven but not punished. But statutes of limitations remain for most crimes. Remain because the psychological rationale has merit, because time really does change people, because the person who committed a crime at 20 really is not identical to that same person at 60. Decades of good behavior do not erase past crimes, do not make them right, do not compensate victims, but they might suggest that prosecution would serve retribution more than any deterrent or rehabilitative purpose, that the social benefit of prosecution diminishes as time passes and people change. There is also a psychological benefit to society in having closure, in being able to move forward. Infinite liability for past actions creates a world where no one can truly leave the past behind, where every person remains forever accountable for everything they have ever done. This might sound like justice in the abstract, but it creates a society without redemption, without the possibility of transformation, without forgiveness or second chances, without the ability to build a new life after making terrible mistakes. Statutes of limitations force a collective decision about when to let go. This does not mean forgetting, does not mean forgiving, does not mean declaring that the crime did not matter, but rather accepting that at some point, the past must stay in the past for society to function. That endless liability is its own form of injustice, that time must eventually heal even if it cannot erase it. In your own life, as you drift deeper into sleep now, statutes of limitations protect you from being held legally accountable for minor past transgressions indefinitely. If you were, say, 17 and committed petty theft, or 18 and drove drunk, or 20 and got into a fight, or made any of the stupid mistakes that young people make. A statute of limitations means that if you were not prosecuted then, you cannot be prosecuted for it 30 years later when you are a different person living a different life. This protection has profound psychological implications. It allows people to move forward, to leave their mistakes in the past, to build new lives without the endless threat of prosecution for youthful indiscretions. It recognizes that human identity is not fixed, that reformation is possible, that people change, that time has moral meaning, that who you are now matters at least as much as who you were decades ago. Yet it also frustrates justice, frustrates victims who must live with the knowledge that their attackers will never be punished. It means some crimes go unpunished, not because of a lack of evidence, not because of reasonable doubt, not because of proof of innocence, but simply because too much time passed, because the calendar moved forward while justice remained undone. This troubles our moral intuitions about accountability, about the permanence of guilt, about the demands of justice. As you settle into sleep, as your conscious mind releases control and allows dreams to form, let this paradox rest in your thoughts. Justice has a deadline. Not because we do not care about past crimes, not because victims do not matter, not because wrongs should go unpunished, but because we recognize that infinite liability for all past actions would create a world without redemption, without the possibility of change, without meaningful closure for anyone. Time matters. Identity changes. People become different through years of living. And at some point, society chooses to look forward rather than endlessly backward, chooses to let some sleeping dogs lie, chooses to accept that not every wrong can or should be addressed legally, especially after decades have passed and the person who committed the wrong is no longer quite the same person who would stand trial. Sleep now, peacefully. The crimes of your past, if minor and long ago, are beyond prosecution. This is both a comfort and a troubling reality, both a protection and a source of frustration for victims, both necessary for society to function and difficult to accept when we think about serious crimes going unpunished. The law recognizes that time transforms, that people change, that justice cannot be timeless even when we wish it could be, that at some point we must choose between endless liability that prevents reformation and temporal limits that sometimes let the guilty escape. We have chosen limits, chosen to let time heal, chosen to allow the past to eventually become unprosecutable. This choice reflects wisdom about human nature and social function, even as it creates individual injustices that trouble our consciences and frustrate our desire for perfect accountability. Rest well. Dream. Let time do its work on your memories and worries as it does its work on legal liability, as it does its work on identity and guilt and the possibility of becoming someone new. The Statute of Limitations stands as a recognition that time changes everything, including the demands of justice, including the person who committed a crime, including the very meaning of accountability when decades separate the crime from the trial. Good night. Law. 11. Presumption of innocence in the court of public opinion. The law, we forget. Our final law is not really a law in the formal sense, not codified in statutes, not enforced by courts, but a principle so deeply embedded in legal systems that we take it for granted when we should be vigilant about protecting it. The presumption of innocence, which we discussed earlier in the context of the Napoleonic Code. But now we must consider its psychological and social dimensions beyond the courtroom, in the realm where law cannot easily reach, but where its principles matter most, in legal proceedings, in actual courts. The presumption of innocence is protected by procedures, by burdens of proof, by rules of evidence, by judges who instruct juries, by appellate courts that review convictions. But in social context, in public discourse, in the vast court of public opinion that exists in media and conversation and increasingly on social media platforms, this presumption often vanishes entirely, disappears as if it never existed, as if the legal principle had no moral weight outside courtroom walls. When someone is accused of a crime, especially a lurid crime, a shocking crime, a crime that triggers moral outrage and visceral disgust, human psychology immediately assumes guilt. Our minds leap from accusation to conviction, from charge to certainty, from suspicion to judgment. Media coverage amplifies this tendency. Headlines scream accusations in large font, while any eventual exoneration appears in small print on back pages. Photos of the accused are shown alongside victims, creating visual associations of guilt before any trial, before any evidence is presented in court, before any jury hears testimony. A narrative of guilt is constructed and distributed and absorbed by millions of people. This is not surprising when you understand human psychology. We are wired to detect threats, to make quick judgments, to believe the worst when danger might be present. We are tribal creatures who trust accusations from within our group and view outsiders with suspicion. These evolutionary psychological traits served us well on the African savanna, helped our ancestors survive in environments where quick threat assessment meant the difference between life and death. But these same traits create serious problems in complex modern societies where accusation and guilt must be rigorously distinguished, where justice requires patience and evidence and careful deliberation. The psychological damage of being publicly accused, even if eventually exonerated in court, even if completely innocent, is enormous, often permanent. Reputations are destroyed instantly, employment is lost, relationships shatter under the strain, and even after acquittal, even after a jury says not guilty, even after the legal system vindicates the accused, the taint remains, lingers like smoke. No smoke without fire, people mutter. Maybe they got off on a technicality. Maybe they had expensive lawyers. The presumption of innocence exists in courtrooms, but rarely in the wider world, where most people live their lives. This creates a profound tension in modern society, a conflict between values we claim to hold. We value free speech, value free press, value public discourse and the ability to discuss crimes and criminals and justice. We want media to report on criminal accusations, to hold authorities accountable, to expose wrongdoing wherever it exists. But this necessary openness creates trial by media, creates situations where accused individuals are convicted in public opinion long before any legal proceedings conclude, creates permanent damage that no acquittal can fully repair. Let us visit a final story, one that captures this psychological and social dynamic, that illustrates how the court of public opinion operates and why the presumption of innocence matters beyond legal proceedings. In 2006, at Duke University, in Durham, North Carolina, members of the Duke Lacrosse team were accused of sexual assault. The accusations were explosive. Rich white athletes at an elite university accused of assaulting a black woman they had hired as a dancer. The case seemed to embody everything wrong with privilege and power and race relations in America. The prosecutor held press conferences declaring the accused guilty, made statements to media about the evidence, about the strength of the case, about justice that would be served. Media coverage was intense, immediate, often assuming guilt from the first headlines. The accused students were vilified in newspapers and on television, and in the early days of social media. Duke University suspended them from the lacrosse team. Some professors published statements condemning them. They received death threats. Their photographs were plastered across newspapers and websites associated with monstrous crimes, their names permanently linked to accusations of gang rape, except they were innocent, completely innocent. The accusations were false, provably false. The prosecutor had withheld evidence that proved innocence, had hidden DNA results that excluded the accused, had violated basic prosecutorial ethics in his zeal to secure convictions. Eventually, after months of character assassination, after lives were ruined and families were devastated, all charges were dropped. The accused were declared innocent, not just not guilty, but actually innocent, by the state's attorney general in unusually strong terms that acknowledged the injustice. But the damage was done, irreversible, permanent. These young men had been tried and convicted in public opinion before any legal proceedings even began. Even after exoneration, even after being declared innocent by the state, some people refused to accept their innocence. The narrative of privileged athletes escaping justice was too satisfying, too aligned with certain worldviews and political positions, too useful for making broader points about race and class and gender, to abandon just because the actual evidence proved them innocent. Some people still believe they were guilty, still believe they got away with it, still believe that powerful connections or expensive lawyers or systemic bias allowed rapists to walk free. No amount of evidence, no prosecutorial misconduct revelation, no DNA exoneration can overcome the initial conviction in the court of public opinion. This story illustrates a painful truth that we must confront as you drift towards sleep. Legal presumption of innocence does not extend to social presumption of innocence. The law can protect you from the state, can require that prosecutors prove guilt beyond reasonable doubt, can ensure due process and fair trial. But it cannot protect you from public opinion, from media trial, from social condemnation that spreads instantly and persists indefinitely. The psychological impact of this disconnect is profound, shapes how we think about justice and fairness. We have built elaborate legal structures to protect the accused, to ensure fair trials, to require proof beyond reasonable doubt, to presume innocence until guilt is proven. But these structures exist in tension with basic human psychology that assumes accusation implies guilt, that leaps from charge to conviction, that treats denials as lies and demands for evidence as deflection. Social media has made this worse, has accelerated and amplified every negative tendency. Accusations spread instantly, reach millions in minutes. Mob justice forms in hours. Hashtags become convictions. Online crowds demand punishment before any investigation, before any evidence, before any trial. And the legal system, with its deliberate pace, its careful procedures, its requirement for evidence and proof, seems hopelessly slow compared to the instant verdict of online crowds, yet rushing to judgment, while psychologically satisfying or while emotionally gratifying, destroys innocent lives. False accusations do occur. not commonly but regularly enough to matter. Mistakes happen. People misremember, misidentify, misunderstand what happened. Malicious lies are told by people seeking attention, seeking revenge, seeking advantage. And every time society convicts someone in public opinion who is later proven innocent, every time we destroy a life based on accusation rather than proof, we reinforce the importance of the legal principle we so easily abandon socially. The challenge for modern society, the work that remains undone, is extending the presumption of innocence beyond the courtroom into social practice. This is psychologically difficult, requires restraint we do not naturally possess. It requires patience in an age of instant information, willingness to withhold judgment in an age of hot takes, comfort with uncertainty in an age that demands immediate certainty. These are not natural human traits, not easy psychological achievements, but the alternative is a world where accusation equals guilt, where anyone can be destroyed by mere allegation, where the protection of legal due process is undermined by social media trials that render legal innocence irrelevant to lived experience, where your reputation and livelihood depend not on facts proven in court, but on narratives constructed online. In your own life, in your own experience as a consumer of news and social media, you likely struggle with this tension. When you hear accusations, especially against people you already dislike, especially about crimes you find particularly reprehensible, the psychological urge to assume guilt is powerful, almost irresistible. Resisting this urge, maintaining skepticism, waiting for evidence, requires conscious effort against human nature and social pressure. Yet this effort is crucial, is necessary for justice, is required if we truly believe in the principles we claim to hold. The presumption of innocence is not just a legal technicality that applies only in courtrooms. It is a moral principle, a recognition of human fallibility, an acknowledgement that we are all vulnerable to false accusation, that justice requires patience and evidence, not immediate conviction based on allegation alone. As you drift into final sleep tonight, as consciousness fades and dreams begin, let this last thought settle into your mind. You are presumed innocent in courtrooms, protected by law and procedure and constitutional rights, but only in courtrooms. In the wider world, in the realm of social judgment and public opinion, you are vulnerable to trial by accusation, to conviction by public opinion, to punishment by social condemnation that can destroy your life regardless of legal innocence. This gap between legal protection and social reality creates injustice, destroys innocent lives, challenges us to be better than our psychological defaults, to extend in social practice the presumption of innocence we enshrine in law, to resist the easy satisfaction of instant judgment, to embrace the difficult uncertainty of waiting for evidence, to remember that accusation is not proof, that charges are not convictions, that all of us are vulnerable to being accused, and that we would want others to presume our innocence if we were in that terrible position. And so we reach the end of our journey, through centuries and principles, through the 11 laws that still rule your life even as you drift towards sleep. From Hammurabi's proportional justice to the presumption of innocence, from written laws for all to the right to remain silent. These principles form the invisible architecture of a civilization, the framework that holds up the world you inhabit. You cannot see these laws, cannot touch them, but they shape every aspect of your life. They shape how you think about fairness, about power, about justice and injustice, right and wrong. These principles were not handed down from heaven. They were created by humans, by people like you, trying to build societies where life could be lived with some security, some dignity, some hope of justice. These laws changed human psychology in fundamental ways. They taught restraint in vengeance. They created accountability for power. They built structures that allow millions of strangers to cooperate in societies far more complex than anything our ancestors could imagine. You are the inheritor of these 11 laws, received from people you never met, from generations long dead. They were built for you, constructed piece by piece over centuries, passed forward through time as if they had always existed. If this journey through invisible systems has given you awareness, peaceful knowledge about the structures that shape your world, please subscribe to Intellectual's Lullaby. There are so many more invisible architectures waiting to be explored. Sleep now. Rest deeply, knowing you live in a world shaped by these invisible structures, shaped by decisions made centuries ago by people who built these protections for abstract future generations. Close your eyes now. Breathe deeply. Let yourself drift. The 11 laws are working. Silently, invisibly, protecting you even as you dream. And when you wake, tune in to our next story. Another invisible system awaits. Another quiet exploration of the hidden architectures that make human life possible. Rest now, peacefully. You are protected by laws you do not see, by structures built long ago by people who are dust but whose work endures. Good night. Sleep well. The invisible architecture holds. The laws that rule your life stand watch while you rest, making tomorrow possible, making justice real. Until next time, on Intellectual's Lullaby. Good night.